Hi everyone, and welcome to today's session on diversity and inclusiveness, in which we're going to take a look at how you might drive your diversity and inclusiveness strategy through positive action and touch on some of the headline considerations from an employment and data protection point of view when it comes to collecting diversity data. We're pleased that you've been able to join us. Let's start by introducing ourselves. My name is David Lorimer. I'm a director in the employment team, and I'm joined by my colleague Hannah Disselbeck, who's a senior associate in the team. This session is the first in our autumn programme of interactive webinars, hosted by Fieldfisher's Employment, Pensions, Immigration and Compliance team, also known as EPIC. We're hosting monthly 30-minute sessions covering the current hot topics and offering practical advice for businesses and organisations. 2 further employment sessions are scheduled, one on the 17th of November on the future of work, and another on the 3rd of December on forward planning, what can UK employers expect in 2021. Our immigration and pensions colleagues are also working through hot topics in their respective fields. Do keep an eye out for invitations to those and sign up. I'm now going to hand over to Hannah to take you through what we'll be covering today.
Thanks, David. You'll see the agenda for today's session up on your screens now. I'll start by taking a quick look at the landscape and at why we're talking about diversity and positive action in the middle of a global pandemic. I'll then briefly run you through the basics of positive action and talk a little bit about the hurdles that a business needs to meet to take measures lawfully. David will then discuss some of the considerations under employment and data protection law when it comes to capturing data to measure the makeup of your workforce and, in time, the success of your strategy. There'll be time for questions at the end. If you have any questions, please use the question box in your control panel on the right-hand side of the screen, and we'll aim to get through as many as possible. If we don't get time to answer all the questions, either one of us or one of your usual Fieldfisher contacts will follow up with you individually after the session. All our sessions are recorded and available on the Fieldfisher website and YouTube channel. Right, let's get started. We're in a state of national emergency at the moment. The pandemic continues to pose huge, in some cases existential challenges for UK business. Given that backdrop, it would be reasonable to ask us why now is the time to talk about positive action, which is not mandatory, though public sector employers should be considering positive action in connection with their public sector equality duty. The answer is that the pandemic creates particular challenges in keeping diversity programs on track, but it also gives us an opportunity for some real blue sky thinking. Diversity and inclusiveness has become, to be blunt, more and more of a mainstream issue, driven by the #MeToo and Black Lives Matter movements. A new generation is coming through for whom a diverse and inclusive working environment is of central importance. Setting aside the fact that there's strong evidence that more diverse workforces are more innovative and effective, any employer wishing to continue to tap into key talent pools going forward will need to show that they can offer a workplace that aligns with the values of this new generation. Now, COVID throws up obstacles for diversity strategies. The pandemic is having a disproportionate impact on certain groups for a variety of reasons. Individuals from an ethnic minority background have been disproportionately affected by the disease itself for reasons that are not yet fully understood. Women are still more likely than men to be primary child caregivers, so have been disproportionately impacted by the closure of schools and by working from home. And while the virus is dangerous for us all, older members of the community are significantly more at risk, as are members of the community with certain disabilities. They're therefore less likely to feel safe coming into work than others. If businesses do not take proactive steps to strengthen diversity measures now, we may see hard-won progress being lost. But it's not all doom and gloom. The pandemic is also an opportunity in that it has the potential to act as a reset. Many large businesses are looking at ways to salvage positives from the disruption and, to use the new buzz phrase, build back better. This may be the perfect opportunity for you to take a pause and map out an ambitious diversity strategy to bring you out of the pandemic stronger. UK equalities law aims to ensure that people are, as the name suggests, treated equally. The simplest way to think about positive action is as an exception to this principle. Treating people differently because of a protected characteristic is unlawful, unless you fall within the exception. It's therefore important to understand how it works. Positive action comes in two flavors: general positive action and what you might call a tiebreaker provision. General positive action can be a very powerful tool in your diversity strategy. The slide you see now runs you through how it works. First, there's a hurdle. For positive action to be lawful, you must reasonably think that one of the three situations described in the first column on the screen applies. That is, you must identify a disadvantage, need, or underrepresentation. I'll look at this in a bit more detail later on. Once you've passed the hurdle, you can then take proportionate action to address the disadvantage, need, or underrepresentation. There's no limit on the action you can take as long as it is proportionate. That means any action you take must be appropriate to addressing the issue that you've identified. In other words, it must have some impact on the problem. It must also be necessary. That means that if there is a less discriminatory way of achieving the same aim, then your measures will be open to challenge. There are a lot of possibilities here in terms of the types of action you can take, and this is an opportunity for some creative thinking. Examples include targeted job adverts, targeted open days or other work experience, in-work mentoring schemes or support groups, diversity targets for senior management or board appointments, etc., etc. The other flavour of positive action is the tiebreaker. Again, there's an initial hurdle. You can only begin thinking about the tiebreaker where you reasonably think that persons sharing a protected characteristic suffer a disadvantage connected to the characteristic or are underrepresented. Once you've met this initial hurdle, you can apply a tiebreaker in recruitment or promotion decisions. Take the following situation. You have two candidates for a senior management position, A, a woman, and B, a man. You've done your due diligence and you've found that women are underrepresented at the level you're promoting into. In this situation, you can use the fact that A is a woman to swing the promotion decision in her favour, but only if your decision meets three conditions. First, A must be as qualified as B. You have some wriggle room in how you make this assessment, but it's not enough to say that A is qualified to do the job. She must be as qualified as B. Secondly, you must assess each situation on a case-by-case basis. You can't have a policy that prescribes that the decision maker must prefer a female candidate in this situation. And thirdly, preferring candidate A over candidate B must be, again, a proportionate means of addressing the issue. Do just be careful of the condition that both candidates must be equally qualified, as this tripped up a very well-meaning employer in the Furlong case, which you may have heard of. Very briefly, the employer in that case, Cheshire Police, had a three-stage recruitment process. The final stage was a panel interview, which was pass-fail. Candidates who passed were deemed equally qualified, and the tiebreaker was then applied to prefer the applications of members of underrepresented groups. Matthew Furlong was a young, white, heterosexual man. He was a strong candidate who passed the final interview, but then lost out because of the application of the tiebreaker. Furlong brought a successful discrimination claim based on the fact that the police had applied the tiebreaker incorrectly. They had treated all applicants who passed the final interview as equally qualified when there were clear differences. Now, this shouldn't frighten you off using the tiebreaker, and it can be helpful. However, if you are thinking of using it, you need to draw up a set of clear recruitment criteria and apply scoring consistently and fairly, so that you're in a position to evaluate candidates' qualifications for a post accurately and objectively, and defend your decision if challenged. You see that handled with a bit of care, positive action, and general positive action in particular, is a very powerful way to boost your diversity strategy, improve representation, and create a more inclusive culture. I just want to take a moment now to focus a little bit on the hurdle you need to overcome to justify the use of positive action in the first place. To justify general positive action, you need to demonstrate to a reasonable standard that groups sharing a protected characteristic are disadvantaged, have particular needs, or are underrepresented. You don't need detailed statistical research here, but you do need to have some reasonable evidence to support the action you're taking. Disadvantage and need are perhaps the simpler gateways to get your head around. Women, for example, are arguably disadvantaged in the engineering sector because of gender stereotyping. Older secretarial support staff may have a particular need for IT training to maintain their performance against younger workers who grew up clutching a Game Boy. However, underrepresentation has the benefit of simplicity, as it requires no speculation about needs or causes of disadvantage. Underrepresentation is clear-cut and objective. If you have the right data, it's easy to establish and monitor and will protect you from challenge. It does require a little bit of thought. First, you can't get an underrepresentation argument off the ground without having a clear understanding of the profile of your workforce. That means you need to collect and hold data on individuals' protected characteristics. Many employers shy away from this unless absolutely necessary due to privacy concerns. However, the data needn't be a block, and David will take you through the relevant considerations. Once you have your workforce profile, there are a few other points to think about. First, what's the activity in relation to which a group is disproportionately underrepresented? Is it your workforce as a whole, particular seniority, or is it a particular type of work, such as IT support or HR, for example? The answer is it can be any of these, though you will need to tailor your solution to the problem you're trying to fix. Second, what's your reference point? You believe a group is underrepresented, but underrepresented as compared to what? The answer is, again, it depends, but you do need to be a bit careful. The EHRC code gives a helpful example of a business with factories in Cornwall and London. Each employs 150 workers. The Cornish factory employs 2 workers from an ethnic minority background, the London factory 20. It looks at first sight as though the situation is worse in Cornwall than in London. However, you need to look at the pool from which the workforce is drawn and to ask yourself what levels of representation you could reasonably expect. In the EHRC's example, the ethnic minority working age population is 1% in Cornwall and 25% in London. The representation of ethnic minority workers in the Cornwall factory is 2 in 150, which is over 1%. It's therefore actually not disproportionately low as compared to the local working age population. On the other hand, ethnic minorities make up only about 13% of the business's London workforce, which shows underrepresentation as compared to the local working age population. This may be a bit of an oversimplification, and there are other ways to establish underrepresentation. However, it is an illustration of the fact that you do need to apply some thought here. Another trap to be aware of is that if you do implement measures, you need to keep reviewing whether they remain appropriate. If the measures are successful in remedying the underrepresentation, you'll lose the justification to continue to apply them. On the other hand, if they show no effect at all, you may need to question whether they're appropriate and therefore proportionate. You see that keeping detailed and accurate data on your employees is likely to be key to implementing a lawful positive action program. So I'm going to hand over to David now to talk about the data angles in a little bit more detail.
Thank you, Hannah. The benefits of collecting, analysing and tracking data relating to diversity and inclusiveness are, by now, relatively well documented. Hannah's already mentioned that having up-to-date data is an important building block when it comes to positive action. Some of the other benefits include it's a tangible step that demonstrates to actual and potential staff that you take this issue seriously. An ability to understand staff better. That includes, of course, knowing the makeup of your current employees, i.e. measuring where you are, but also, in time and as data is built up, demonstrating or measuring progress, or getting an insight into particular barriers where employees of a particular demographic stop progressing within the organization, for instance. In turn, that drives action and informs a specific strategy for ensuring a workforce that's diverse, which, as Hannah has said, increases innovation and effectiveness. Of course, it's also important to recognize that in capturing diversity data, you'll be asking applicants or employees to share information which is inherently private and sensitive in nature, particularly, for instance, when it comes to race and ethnicity, the existence of a disability, or gender non-binary identity. Because of that, there are extra legal protections or limitations which employers must consider before moving forward with this data collection. Firstly, data protection law. Data protection law will apply provided the data is not collected and used anonymously. It's worth pausing here and noting that data collected through web forms and along with application forms will virtually never be genuinely anonymous, at least not to the standard set out under the GDPR. And so we'd urge employers to be extremely cautious before proceeding on that basis. The most significant data protection hurdle here is likely to be ensuring that the collection and use of diversity data is lawful. As most diversity data will be special category data, or what used to be referred to as sensitive personal data, in the UK, that usually requires identifying and relying on, firstly, a legal basis under Article 6 of the GDPR, secondly, an exemption to allow processing of that sensitive information under Article 9 of the GDPR, and thirdly, a condition under Schedule 1 of the UK's Data Protection Act 2018. That sounds complex, but it needn't be. Many employers will look to rely on either the collection being necessary to fulfill their employment law obligations or the explicit consent of the applicants and employees in question. However, those routes are not necessarily safe because employee consent is challengeable and can be withdrawn at any time, or in some instances available, because there's no general positive requirement on all employers in the UK to collect diversity data under UK law. Instead, employers in the UK ought usually to be able to rely on the basis, exemption and conditions which apply where the collection of this data is in the substantial public interest in order to monitor equality of opportunity or treatment between particular groups, to borrow the technical language of the statutes here. There are other data protection hurdles which should be navigated before collecting diversity data, including ensuring that you're transparent about the collection, having in place a specific policy document governing your collection and use of this data, and carrying out a data protection impact assessment to document how you are lawfully collecting this information. But establishing the lawful basis, exemption and condition, i.e. the lawfulness, is often the most challenging data protection hurdle. On to employment law then. Unlike in other EU territories, there's no specific and generally applicable ban on the collection of diversity data in the UK. And in fact, the Equality and Human Rights Commission's Statutory Code of Practice strongly recommends capturing this data. But care does need to be taken here. Particular hurdles to navigate will include the qualified ban under the UK's Equality Act on asking questions about an applicant's health before making an offer of employment. It's also important to bear in mind that collection of diversity data during any recruitment process can increase the practical likelihood of claims from unsuccessful applicants who've disclosed their particular protected characteristic. Of course, in practice, that just means that care should be taken to ensure the real and non-discriminatory reasons for not moving forward with particular applicants can be evidenced. Finally then, privacy law. Applicants and employees, of course, have an expectation of privacy when it comes to this kind of data. The right to respect for one's private life doesn't prevent employers from taking action to monitor the makeup of applicants and employees, but it does need to be borne in mind here. So, for example, it's particularly important that employers are able to justify the collection and use of this data and that sensible safeguards are put in place to protect it, in line with the more specific security requirements under the GDPR. Going beyond the scope of UK law for a moment, a question that frequently arises is, can we take a globally consistent approach when collecting diversity data? Whilst there are obvious advantages of adopting a joined-up approach, there are, unfortunately, some hurdles to that. Those include differing legal regimes. So there's an outright ban on collection in some countries where constitutional law, local non-discrimination, and even guidance from local data protection authorities can come together to mean that collection in a non-anonymized way is limited, unlawful, or in some territories, a criminal offence. For instance, in France and Italy, collection of certain diversity data in an identifiable format represents a significant hurdle. Culture, our second factor here, is often the driver of legal challenges. And in some countries, it's simply an entirely alien concept that an employer or would-be employer would ask an applicant or an employee to disclose their diversity data. Of course, seeking this data is also more likely to be challenged in practice where it is countercultural. Classifications adopted for each diversity marker can also vary from country to country. The same terms can be accepted norms in some countries, but not recognized at law or societally in others. For instance, in Germany, a third gender category, referred to as diverse, which essentially means miscellaneous or none of the above, is commonly used. That's clearly not replicated in the UK. In practice, all of these issues mean that organisations often need to adopt a per territory strategy, which allows the collection of the most meaningful possible data in light of the legal limitations. This can be a difficult issue for global organisations headquartered in more permissive territories, for instance the US, to understand, but it is really important to bear in mind. The good news, of course, is that, as I've hopefully explained, the UK is a relatively permissive territory when it comes to the collection of this data.
Great, thanks, David. I've been keeping an eye on the questions while David's been speaking to you, and we have had a few in. So perhaps if we take the last few minutes of this webinar to go through a few. So the first of these, I think, David, this one's for me. We're a public body, so we're subject to the public sector equality duty. How does that interact with the positive action provisions? That's a really good question. As I said earlier on, positive action isn't mandatory, and it's not mandatory for public sector employers either, but public sector employers are under a public sector equality duty to have due regard, that's the technical language, due regard to the need to advance equality of opportunity. Now that includes the need to consider the first column of that slide I spoke about earlier, so the need to consider whether there's a disadvantage or a particular need shared by certain members of groups, or whether there's underrepresentation. That means really, I think to read across that means that a public sector employer is under an obligation to at least consider whether positive action measures might be appropriate or necessary for the workforce. But it probably doesn't go so far as to impose an absolute duty to take positive action. The only thing I would add to that is, in fact, most of the positive action and the more assertive positive action programs that we've seen have been in the public sector rather than the private sector. So I think that's probably for that reason. Right, looking back to the questions. David, I think this one goes to the data collection points you were making. If we can't take a harmonised approach across all territories, what can we do?
Another good question, or a short one with a potentially long answer. The best option is likely to be to adopt a patchwork or per territory approach. That's the best option because it ensures that the data collected is as meaningful as it can be in each territory. The obvious alternative is to adopt the kind of standard approach that can be rolled out in the least permissive territory, but that often means capturing less meaningful data, making surveys completely voluntary, which in turn often drives participation down and gives a less meaningful snapshot into where you're up to. It also often means that data can't be tied or tracked, which means it's more difficult to measure progress.
Great, thanks, David. Okay, here's another one. I think for me, on underrepresentation, can I just look at how my workforce breaks down, e.g. just 30% of workforce is female? That's another good question. I think there's probably a bit of a trap here. So the EHRC code does actually give an example of an employer looking at the makeup of their workforce, and that is a gender diversity example. So it's basically the example you're giving. You need to be a bit careful. The thing about gender is that there's a kind of common sense assessment to be made that 50% of most local working age populations is likely to be female. I mean, that's not very scientific, but the breakdown is going to be roughly 50-50. That means that for gender diversity, or sex diversity, I should say, it's easier to just look at your workforce and see how the makeup shakes out on those 50-50 lines. That may not work for other protected characteristics where you don't have a 50-50 split in the working age population. So that's where the Cornwall and London examples came in. I suppose the only other thing to add to that is where it may be appropriate to compare one level of your workforce to another level of your workforce. So if at the intake level you have 50-50 men, women, but at senior levels you find that your representation is 30-70, then that's probably going to be a valid comparison for the purpose of getting you over that hurdle. Right, one more here. Advise on how to start planning a D&I strategy for an Irish company. Yeah, I think I might start on that one, and then David might have some comments on the collecting of data. But I think when you're looking at UK law and diversity in your UK workforce, it really comes down to, first of all, you need to look at your workforce and see where you see the underrepresentation and whether you see a diversity and inclusiveness program to be justified. And then you can take a step to think about what kind of appropriate general positive action measures would be. But again, I think that first step is looking at data collection. So I think that's where everything David's been saying comes in. David, I'm not sure whether you wanted to add anything to that one.
Sure, yeah, I think just very briefly, I think taking a first step is important. I think from what I've seen elsewhere, a very good practical suggestion is to look at what's best practice. Quite a lot of companies are now publishing their own strategies or strands of them and measures they've adopted. So it's worth having a look at what's good. It's particularly worth having a look at what's good and what's worked in your industry. And yeah, as Hannah says, look, the data is going to underlie a lot of this. So, do think about how you might design how you first capture the data that reflects your workforce, and factor in the kind of legal limitations that we've talked about.
Thanks, David. Okay, perhaps a moment just for one more. And again, I think this one's for you, David. Can companies choose whether to make diversity data collection voluntary or mandatory?
I think in a word, yes. But what I would say is that if you're going to rely on the consent of employees pursuant to data protection legislation, then you're going to need to make it genuinely voluntary. But as I've said, there's real concerns about taking that approach anyway. If you can rely on a non-consent basis for processing, then you can look to make it mandatory. Mandatory is too strong a word because you're never going to twist anyone's arm behind their back, but you can rule it out and not rely on it being genuinely voluntary, as it were, which might increase uptake.
Thanks, David. I think that's probably all we have time for in terms of questions. So I'm just going to hand back to David to make a few closing remarks.
Great, thanks. Yes, I agree. I think that brings us to the end of the webinar. Thank you everyone for joining today's session on diversity and inclusiveness strategies. We hope you found it useful. As we mentioned at the beginning, our sessions are recorded and can be found on our website and on the Fieldfisher YouTube channel. I'm sorry if we haven't managed to get to all of the questions. If you did have any questions we weren't able to answer, your usual contacts should be in contact to follow up with you individually. If you'd like to talk about this topic further, we'd be delighted to talk to you more about it. Please do get in touch with your usual Fieldfisher contacts and they'll refer you on. In the meantime, keep safe and we hope you can join us for our November session on the future of work. Goodbye.
Bye.